Hi everyone, thank you so much for coming today. I really appreciate your time. And for those who don't know me, my name is Mariam Ajunyan. I'm a local real estate agent with Compass, and today we have the pleasure of Mark and Dina with Lodger Loaf for law firm here coming to present us and teach us technically what is living trust, what is will, and what are the differences, and having that in place, how can that technically secure and
protect.
Yes, that was a good word. Protect our family and us. So with that being said, I want to just give you a background. I met Mark years ago at one of our office mixers, and I thought Mark is such a great, passionate, knowledgeable in what he is doing.
I like her.
And we decided to do our trust,
Well, you decided.
We decided.
Yeah, I didn't decide anything.
No, I
you
didn't.
decided to do
I told you, yes. We did our family trust with Mark, and I thought this is such an important subject and overlooked with so many people that this would be a great educational presentation by them for you guys to learn about. And I really appreciate you guys,
Thank
your
you.
time being here on a Saturday in a holiday season. And with that being said, I want you to take over the stage. Thank you so much.
Thank you very much, Mariam.
Thank you.
To Miriam's point, I want to thank all of you for coming today. This is not like something people want to do, and you're not necessarily going to see the result of it. It's not like a retirement or a savings fund. This is something that you do for the people that you love. It's a responsibility, but a lot of people kind of put it off. In fact, recent statistics, I think, show 33% of all Americans don't have any estate plan. Not a will, not a trust, nothing. So if you don't have one, you're one of those people. Oddly enough, only 33% have an estate plan, but last I checked, there's a 100% chance of dying at least at some point. None of us get out of this alive. So keep that in mind. All right, so we're going to go up. What we're going to go over today, I'd like to do a little agenda. So we're going to talk about why the typical estate plan fails and can leave your family in conflict and court. A lot of people don't understand even what an estate plan is. It sounds like a very fancy term, but it's something that we all need. We're going to determine how to determine if your family is at risk, and if you have anything, if you have a house, if you have a savings account, if you have kids, you are at risk. We'll talk a little bit about that. And we're going to talk about what to do to save your family money, protect your assets from outsiders, and actually leave a true legacy. Now, before we go into the details, I'd like to introduce myself a little. And Miriam, you gave a very nice introduction, but I'd like to go into a little bit more so you guys know who you're listening to. So I went to law school and I took an estate planning course, and I loved it. Professor comes out, he says, best area of the law. You're not fighting with people, you're making a difference in their lives, and you get to maintain a long-term relationship as opposed to just finishing a case and sending a bill. And that appealed to me greatly. And I really wanted to do that straight out of law school. The problem is a lot of my friends told me, oh, it's so boring. It's death and taxes. Who wants to do that? So after law school, I went to go work in the real estate field, real estate investment. And it's partially why I met Miriam. And then 2008 hit. I don't know if anybody remembers, but it wasn't a great year. There was this thing called a recession. And for me personally, it was a little bit harder. My dad got sick. He stopped remembering stuff, and he was ultimately diagnosed with Alzheimer's. And, cobbler's kids don't have shoes. My parents did not have an estate plan. So I actually spent a lot of time, I hate saying this, impersonating my dad, signing stuff on his behalf, and it was really bad. It created a lot of issues and really made me realize how important estate planning is. So in 2008, when the recession hit, I was laid off, and instead of going to work for somebody else, I opened up my own firm. And I wanted to do estate planning because it's what I wanted to do when I was in law school. And I found that it was not boring, it's not death, it's not taxes, it's actually life. It's actually legacy. And it has changed my life. It has given purpose to my life, and it has elevated my life. So best thing that could have ever happened to me, and now I'm on a mission to make sure that everybody kind of feels and knows why this is so important. Again, it's not something that people want to do, but it's something that we all have to do. Now, before I go on to the next slide, I think, Dina, why don't you take a moment to introduce yourself?
Yeah. So my path is a little different from Mark's. When I was in college, my parents said to me, as long as I stayed in school, they would foot the bill. So it was law school or medical school. And couldn't stand the sight of blood, so law school it was. Ironically enough, Mark and I went to the same law school, and I actually had the same professor. My path into estate planning, though, is my father did financial planning. And so it was a natural segue for me to go into estate planning. And I practiced law for a little bit, and then I got pregnant and decided to take a break from my career to raise my kids. And while I was raising my kids, I dabbled in some other things. I got my real estate license, and then about 15 years ago went back to school and actually got my master's in marriage and family therapy and became a therapist and worked primarily with couples and communication, and did a lot of training in certain modalities. And I did that for a while, and then decided to go back into estate planning because I felt like it merged all of the things that I enjoyed doing, and my unique set of skills as a therapist really come into play both on the estate planning side and on the trust administration side, and we're going to talk about both of those. So my path has been a little bit different. I love what I do. I love working with families, helping them on the planning side and on the side after they pass away. And recently, Mark's practice merged with Lagerlof, and that's how Mark and I got involved. And so here we are.
Great. So the first topic that we're going to talk about is guardians. I think almost everyone here has little kids, right? Okay. I actually happen to think that if you have young kids, this is the biggest reason that you need to get an estate plan in order. Nobody knows your kids better or who should watch your kids better than you. And if you don't make that decision, a court's going to. And the court doesn't always make the best decision. So my kids are older now, but I can tell you that when they were younger, I had two potential, couples that would have been possible guardians for my kids. And they were both my brothers. One brother was married to my ex-wife's best friend. They had two kids, I had three, but their two almost matched up perfectly in age to my two. They were all best friends. My other brother was single. The one that has the two kids is 2 years older than me. The one that is single is 6 years younger than me. Not married, no kids. So if you're a judge, you're probably looking at two people and you're looking at potential guardians, and you'd probably pick the brother that is married to my ex-wife's best friend and has the same age kids as I do. That would be completely wrong. What the judge would not realize is that brother had a very bad marriage. His wife did not have the values that I had, my ex-wife and I had. And believe it or not, my kids would have been much better off with my single brother. So pick your best guess is always going to be better than a judge's. So making sure that you have guardians in place, to me, is probably one of the number one reasons that you really have to have an estate plan in place. And there's more to just naming permanent guardians. You want to make sure that you have medical powers of attorney. So let's say that you're not around and you want your parents or the kid's grandparents to be able to take them to a doctor, you're on vacation. So planning around your kids, to me, if you have them, is the fundamental reason to start doing your estate planning. So after that, California has a plan for you. And Dina was going to talk a little bit about what California's plan is.
Right. So if you don't have a plan, what does that look like, right? So California has a plan for you.
What does that look like, Dina?
Well, it looks like it's called probate. And some of the things about probate are that, well, what is probate? So probate is a court process that transfers your assets to your heirs. And California decides who your heirs are, who's going to get your stuff. And I love this quote. Probate is a lawsuit you file against yourself with your own money for the benefit of your creditors. And that's really what probate is. I don't know if any of you have gone through probate. Have any of you had to deal with a family in probate? It really is an arduous, difficult, long, expensive process. And, you know, it takes somewhere around 18 months today. Now with COVID, it's taking longer for some estates. The court supervises every part of the process. Everything needs a judge approval. There's accountings. It's a lot of work. It's public. Every part of this process now becomes public, and it's very expensive, which Mark is going to touch on. And again, California makes the decision. So California decides who's going to get your stuff. You may have a sibling that you don't want to inherit. Guess what? If that's who's the one next in line, that's who's getting all of your stuff. Here's the great thing. This, completely avoidable. So now I'm going to let Mark talk.
So, you know, it's funny. I talk to a lot of people, and most people know that, you know, you want to avoid probate. They don't really know why they want to avoid probate. They just hear that it's a pain in the butt. And Dina's talked a little bit about how it's long, it's public, and it's expensive. The expensive part, I think, is what most people. The expensive part is what most people want to avoid, even though the time and the court process is also a big deal. So I just kind of want to go through a really brief scenario of how probate is calculated. This usually gets people very motivated. So the first thing that's going to go into your probate estate is your home. It used to be $1 million home was a very expensive home. In California, not so much anymore. So in terms of calculating how much your estate is worth, it's important to note that the home is going to go in at its fair market value. So in this scenario, we have $1 million home. For many people, they'll take out a 80% loan. It's $800,000. So your equity may only be $200,000, but for probate calculations, it's $1 million. I just threw in stocks, bonds, bank accounts. I just put $100,000. And then I also put in life insurance and retirement accounts. So this is really important. Typically, anything that has a beneficiary on it, like a life insurance or retirement account, will avoid probate. It goes directly to whoever you want it to be. The problem is when you have little kids, like everyone here does, if the child is the beneficiary, the rule that I just mentioned doesn't apply. It will go through probate. And it makes sense if you think about it. You know, you have a 10-year-old who's a beneficiary in a life insurance policy. The court's not going to give the 10-year-old money. So the court has to supervise that process. So in this case, we had $1 million life insurance and retirement policy. So that's going to be sucked back into the estate. So we have $2.1 million. So probate fees usually consist of two parts. There's the the executor fees. That's the representative to the court. And there's the attorney fees. So sometimes the executor will waive their fee, not always though, and the attorney almost never waives their fees. So typically, 2.1, we actually did the probate calculation. For a $2.1 million estate, the estate is going to pay between $34,000 and $68,000, depending on whether the executor wants to waive their fee or not. That's $34,000 to $68,000. That's completely avoidable. No one has to pay that. But if you go through probate, that's the only way you're going to get your assets out of the estate and to your children. So that's a major factor for a lot of people and why they want to avoid probate. Mm-hmm. Yes?
No, I'm smiling.
Okay, fine. So I mentioned in the previous slide that we might have a situation where you have life insurance or retirement benefits payable to a minor. So it's going to go through probate. And if there is no trust and there's no other estate plan in place, that beneficiary, that child in this example, that 10-year-old that I just used, will inherit everything at 18 years old. 18 years old. Last I remember, I was not that responsible at 18 years old. Getting $2.1 million to me probably would have been not the best thing. So I actually have an 18-year-old right now, and he has recently discovered online gambling. Swear to God. And he's not very good at it. I don't know if anybody's really good at it. I think he told me he's lost a couple $100, which is a lot of money to him. I just want you to think about what an 18-year-old would do with $2.1 million. Growing up, we had, my parents had these friends. It was a blended family. And the daughter, the one that was my age, her father had died and left her as the beneficiary. And the mother had no control over it. And the daughter and the mother had developed a very strained relationship. And when the daughter turned 18, she basically told her mother, I don't need you anymore. And she basically went through $1 million insurance policy by traveling and buying stuff, and her mother had nothing to say about it because nothing was put in place. The father didn't expect to die. He had a life insurance policy and put his daughter on it. It's a very common thing that we do. Actually, it reminds me, going back to what Dina was saying with regard to probate, blended families, I don't know if anybody here is in a blended family, really, really, really require estate planning because you never know stepchildren's relationship with a step-parent, and it's usually fraught with really horrific issues. Okay, but wait, before you go on, so the number one thing that I hear often from people who don't have a trust is, oh, I have a will. I don't need an estate planning attorney. So now I'll let Dina talk.
Okay. But I have a will. So let's talk about that. First of all, if you have a will, your estate still goes through probate. Let me say that again because everybody forgets that. If you have a will, your estate still goes through probate. What a will does give you, though, the difference between the California plan, which is what I discussed earlier, and having a will, in your will you get to say who gets your stuff. So now at least you can say, I don't want my sister Sally to inherit. I want my estate to go to my friend Fred. So you can, that's the difference between the will and the California plan. Everything else is the same. You're going to spend the money. It's going to be public. It's going to be long. And so, a will really for most people is not sufficient. So then we say, well, what is a trust? Well, a trust really, it's a contract. And what you are doing is you are contracting out of the probate system. And the other thing that people don't think about is we're talking death, and there's a lot of death talk here. But for a lot of people, there is a long period of time that you could become unable to care for yourself, whether you're incapacitated, you were in an accident, you have, for whatever reason. Well, then what happens to your stuff? Who's paying your bills? Who can call the bank account? Who can call and deal with your stocks? I have a client right now who called me up and said, I can't talk to my mom's stockbroker and I need money to pay for her care. Well, guess what? You can't. You're not on the account. If you have a trust, and I'm going to talk about how that works, and the account is in the trust, you now have the ability for somebody to help you with your financial, with finances or whatever you need upon incapacity. So that's another difference. So what is a trust? A trust is a contract. It's a contract between three people. You have a trustor, a trustee, and a beneficiary. While you're alive and you're healthy, you're all three. You're always the trustor. The trustor is who creates the trust and puts the property into the trust. The trustee is the person who's responsible for carrying out the terms of the trust. And then the beneficiary is who benefits from the trust. And so the other thing that, because this is a contract, you get to make all the terms of it. And that's what Mark and I really love to do, is work with you. Who do you want to get your stuff? When do you want them to get it? Maybe your kids, you want them to get half of it at 28 or 30 and the other half at 35. How do you want them to get it? Do you want them to get it outright? Do you want to keep it in trust a little longer for them? So we work with you. You tell us what you want, and we make sure that we create that. And that's what we can do within a trust.
Okay. It's going to go? Oh, it's not going to go. Good. All right. So now by this point in the presentation, you understand that if you own any real estate, for sure, you need a trust. And for most other people, you need a trust. The problem is, and Dina mentioned this, a trust is only a contract. And while it's nice and pretty, a contract still needs other things to go into it. So the way I often describe a trust is, it's a nice little stack of papers, but you have to put everything into the trust in order for it to work right. So,
and I'm going to just step in. Pet peeve,
please.
A lot of attorneys will hand you this beautiful trust, and they leave out this part of the discussion.
And to that point, this has happened at this point probably 10 years ago. I had a friend whose father died. And he brings me his dad's estate plan. And it's beautiful. I mean, it's in a nice binder, it's on nice paper, and it has all the terms of what dad wanted. And on the very top, there was a letter from the attorney that says, Dear Joe, congratulations on actually putting together your trust. Here are the next steps that you need to take in order to make your trust work well. And like all of us, Dad procrastinated and never took any of those steps. And I think he spent like $5,000 on the trust, and it was completely useless because there was no follow-up and there was nothing in the trust. So when I say fully funded trust, just to give you an idea of like what needs to be done, so like investment accounts. I think I have a little thing here. No, I guess not. You really have to title all of your investment accounts, whether they be stock accounts, bond accounts, crypto accounts. You're going to have to go to the bank, and you're going to have to sign new signature cards because the trust needs to be the name of the trust will be the new owner of the account. You as the trustee is actually the owner, but it'll read, Joe Smith, trustee of the Smith Family Trust. Deeds on real property. So we always do this for our clients, at least for the home. The house needs to be in the trust. It is typically, the most expensive asset for a family. So on that $1 million, take away everything else. Take away that life insurance, take away the bank accounts, everything. Just to get that $1 million house out of probate, it's going to cost about $40,000. So, and it's a really easy thing that we will do. We usually don't let clients get away with not at least putting their house in the trust. Stock certificates, similar to the titling real property. Assigning your personal property. Personal property is kind of easy. You have some artwork, you have some jewelry. Things that don't have titles on them are usually easy to transfer. So we usually do that in a letter as opposed to changing the title. And then the last thing is the things that have beneficiaries on it. So I mentioned before that anything that has a beneficiary on it avoids probate. Usually you want it to go through your trust. Not changing your beneficiaries, though, really can also lead to some big problems. There was a case I read about a few years ago where a couple got divorced, and the husband had his wife's name on the beneficiary for the life insurance, and then they got divorced. And the ex-wife said that was her life insurance policy, and the current wife said, no, it's mine, but the beneficiary designation actually wins out. So even if you have something in your will, a beneficiary designation is going to win out. Even if you have a trust and you don't put the trust as the beneficiary on the trust is going to win. So if there's two things you're going to walk away from today, one is you need a trust, and that two is you need to fund that trust. I think this is also fun. We're going to give you, it's like free money today.
Yeah, this is kind of a fun fact. $8.2 billion is sitting in unclaimed property. All you have to do is go online, you Google it. We should actually put the website. I'm going to do that next time. So, true story, have a client, did trust administration. Parents had $28,000 in unclaimed property. So one thing to walk away with, another thing is check your unclaimed property. But there are things like this that we talk you through, and we're going to get to there a little bit in what we call the trust administration, what happens when somebody dies. And this would be something when somebody comes to me as part of the list of what I tell them to look at, but just a kind of a fun little fact.
And the reason that we include this fact is Dina and I spend a lot of time working with our clients and understanding what they have. Whereas if you go to a LegalZoom or a fly-by-night attorney, they're just going to put together the documents. They're not going to look at your assets. And if you don't look at the assets, both as the person who's forming the trust or as the attorney, things get lost. And when things get lost,
They end up there.
that's how they end up. So that's one of the reasons we included there, because when you work with an attorney, you at least want to make sure that your attorney has a good schedule of what you have. Death tax. So got good news and bad news. So this is referred to as many different things. Death tax is probably the most common. It's also called the estate tax or an inheritance tax. There's good news and bad news. The good news is that I believe in 2022, only 0.2% of people actually had to pay any estate tax. So that means 99.8% of everyone who died in 2022 so far paid nothing in estate tax. And the reason for that is everyone gets a credit. It's called an exemption. So for 2023, it goes up every year. For 2023, that exemption is $13 million per person. So if you, as an individual, have less than $13 million in assets, or as a couple, each person gets their own, $26 million. If you're under that number as a couple, you pay $0 in estate tax. And a lot of people are also happy to know that the person who is inheriting, whether it be your children or a relative, they pay $0 in income tax. So death is actually kind of a really good thing for people who inherit because there's no tax due. I don't think it applies to anyone in here. If it does, you need to do some planning. Important to remember that 2026, this $13 million goes down to $5 million. Congress may change it. They often do, but it's called a sunset provision, meaning that it's when they passed it originally, I think when Trump became president, he doubled it from like 5 to 10, and then just kept on going up because of inflation. But the law actually goes back to the $5 million in 2026 unless Congress extends it. So we'll see what happens. So that's the good news. The bad news is if this does apply to you, the tax rate is 40% of every dollar above the exemption. So if you're a single person in 2026 and you have $6 million, you have a $5 million credit, but that $1 million is going to be taxed at 40%. So it's a $400,000 tax. So avoiding that is also something that we often work on to make sure that the family doesn't have to pay a really, really hefty tax. All right, let's talk a little bit about asset protection, Dina.
Sure.
Okay, cool.
So, so asset protection is you've worked really hard for what you've earned and you're proud of it and you want to pass it down to your children and maybe to your grandchildren. And so part of what we use the trust for, the trust is used in a couple ways. As Mark said, some of the things we do are to avoid the death tax. But the other part of it is really for family planning and the asset protection. How can we make sure to protect what you've earned is going to your kids? And who are we protecting it from? Creditors. You're protecting it from maybe from your kids in certain situations. We can leave your assets in trust, but make sure your kids are provided for. Maybe they're going through a divorce. Maybe they have a mental health issue. So we create your trust in a way that those assets are protected so that your children can get the benefit of them, but they can't take everything and run with it, like Mark was saying in some of his examples. You know, you may also have a child with disabilities who needs a special needs trust. So again, this is where we really work with you. This is where LegalZoom can't say, what am I looking at and how do I protect this family? That's what we do.
You're not done yet.
I'm not?
No.
Oh, I am not done. Okay. Then trust administration. Okay, so now someone's died. Now what? That's what we call trust administration. That is the process when you don't have to go through probate. You've contracted out because you have your trust. Now what? And that's, as I said, what we call trust administration. Here's the great thing. In your trust, you've said who gets your stuff, how they get your stuff, and when they get your stuff. But how does that happen? So a lot of people, especially if somebody's married, just assumes it's all going to the spouse anyway, and they don't do anything. Well, down the road, you can have a lot of problems because there are certain things that are required to happen and certain deadlines. And when you don't do them at the first death, assuming you're a married couple, it creates a lot of problems at the second death. You could lose the tax benefits. You could lose the asset protection. And there is also a fiduciary duty on the person who's acting as trustee. Let's assume there aren't kids, or there are blended families, as Mark is talking about. You could be personally liable for not doing some of these things. So I cannot stress enough, again, in this kind of era of LegalZoom, or I'm going to do it myself, we can work with you to just say, make sure you're doing these things, and there's a lot you can do on your own. You can have us do it. But it's so important to contact an attorney and really make sure that you're lodging the will within the amount of days it's supposed to be lodged, or notices have to go out to heirs. Well, guess what? If you don't send those notices out, the timeline on their ability to come back and sue you as trustee doesn't start. So now you have unlimited liability. Whereas we send a notice out, that starts 120-day clock ticking. Boom. Once that 120 days is done, they cannot come after the trust. So there's a lot of things that people don't know and why it's so important. Also in terms of real estate, you want to go sell your real estate. The records show there's 2 trustees. Guess what? There isn't. There's 1 trustee. So now you're in a quick sale. There are things that we can do, but now you're rushing to do it all as opposed to having done the administration right. So that's what trust administration is and why it's really important to do it with an attorney.
Stay where you are.
Okay.
You can stay.
Okay.
Miriam is a realtor, and I'm sure she's familiar with it. We talked a little bit about why a trust is better than probate. So, for example, if you want to go sell a house, your parents' house, whoever passed, and you don't have a trust and the house is not in the trust, you have to get permission from the court to sell that house. You have to get approval of the commission, and you have to get approval of the sale price. Whereas in a trust, your trustee gets to do all of that independently. So just an example of how trust administration works so much better than actually doing it via probate. So hopefully you've taken away a lot. It's funny, it's the holiday season, and I was actually thinking about, before I came here, that my kids want to take a vacation. And I was actually thinking about how much more time probably all of us spend planning a vacation than we do our estate plan. And yes, a vacation is so much more fun and exciting, but an estate plan is so much more important and valuable. So if you take away something from this, I hope you understand that the planning is really important. It's not just, though, the planning. Dina mentioned LegalZoom. There's a lot of people who try to shortcut the whole process, and they'll either go online and fill out some documents, or they'll go to some attorney who doesn't charge a lot of money, and they think it's just a set of documents. One of my things that I tell clients, and Dina really likes, is my documents are free. It's the advice that you're paying for. So whether it's us, whether it's a very good attorney, I'm not as concerned with who you use. Of course, we'd like it to be us. My primary concern for anybody that I like and care for is that you find somebody that is good and reputable and is going to make sure that you have a plan that works when you want it to work and how you want it to work. Thank you very much for taking time with us.
Thank you guys very much
and we
for
really
coming.
appreciate it.
I have a question.
Yeah.
No, we have to repeat the question. Don't worry, we got it.
Okay.
You repeat the question.
Okay.
Okay, say a family goes through the whole process, they set up the trust, it's looking good, so if something happens, they'll be okay, and they've filled in all the parts, they've done all the follow-up. Trust in place. After it's existing, what are some benefits to having that trust? For example, I see that I always assumed this was an uber rich thing, but I guess not, where people do their donations through the family trust. What other benefits are there to having that trust?
Okay, wait, can I have so many responses.
Yeah.
So I think there were a couple questions in there. So if I don't get to them, let me know. So one is, do you need to update your trust? I think that's kind of part of what you were saying.
Oh, no, I'm saying once it's established and you're looking good and
What
the
are
trust
just-
is in place,
Okay,
what
well-
are other uses for that trust?
Yes, but when you say it's established, it's looking good, it reminds me that I do want to say that a trust is not a set it and forget it document.
Right.
So
It's a living trust.
It's a living trust. That's good. I like that.
Yeah.
So I usually recommend at least every 3 years you have an attorney look at your trust. Sometimes more often, especially if there's been a death, a new child born, any sort of event
You've
that
inherited money.
you've inherited money, but at least every 3 years. So, you say you establish a trust, but it's not a set it and forget it. In terms of how do you use your trust, so you mentioned making donations through your trust. So there are two basic types of trusts. There's revocable and irrevocable. So what we've been talking about today is an irrevocable trust. It's a living trust.
Revocable.
What?
You said irrevocable.
Revocable, sorry. It's a revocable living trust. It can be changed. It can be totally dissolved. If you divorce, you want it dissolved. You can put stuff in. You can take stuff out. At its core, as Dina said, it's a probate avoiding vehicle. That's what a living trust, a revocable living trust is. What you are referring to, like through a foundation, is often an irrevocable trust. So what some families do, and it usually is the wealthier, is they put money into an irrevocable trust to get the money out of their estate. So we talked about $13 million as the exemption amount. If you have a $20 million estate and you take $7 million and you put it into an irrevocable trust for charity, it's not taxable. It's not included in your estate. That 40% that I mentioned never gets charged. And so some families would rather take that extra $7 million in this example and create a foundation for their family to give away money. A revocable trust, a living trust, at its core is you. So you don't file a separate tax return for your living.
I was just going to say all of that.
You don't file a separate tax return for your living trust. The Social Security number, your Social Security number is the same Social Security number as your living trust. So it's really just an alter ego of who you are. But in terms of what you can do with your living trust, you can do a lot. You can give money to charity, absolutely.
Well, because it's you.
It's you.
So it's acting however you would be acting.
You can use your trust for asset protection. As Dean, I think, said, you can control how your money is distributed, when it's distributed, and to whom it's distributed. So a living trust, even though at its core it's a probate avoiding vehicle, you can do so much with it in terms of structure and how you want your wishes to be carried out, both when you die and even if, God forbid, you become disabled or incapacitated, and how you determine that incapacity. So that was a lot, but did that answer all of your questions?
Yes.
Okay, great.
And that goes at what he touched on the last. What is the main benefit of having the trust while you're alive? Is this ability, if something happens to you, you now have a vehicle for somebody to help you.
Okay. Now,
Otherwise, it's an alter ego for you.
That there's separate types of trust.
Yes.
Ernest.
In regards to asset protection, when you put, let's say, your property in the trust, can somebody sue you and reach out to your property? Let's say, for example, your dog bites somebody and
Right.
they want to go after your house.
What Ernest was asking is, does a living trust offer any sort of asset protection? And there are two huge misconceptions when it comes to a living trust, a revocable living trust. One is that it avoids estate tax. It does not. A revocable trust does not avoid any estate tax. For most people, it doesn't matter, but people think it does, so I just want to make that point. Second is people think that a living trust avoids liability. And I think the confusion arises because an LLC does have liability protection, so people think a trust is a form of like an LLC or a corporation, or it's a different entity. The problem is, and the sad truth is, a revocable living trust has no asset protection. None. Like we were saying with Eleanor, it is basically just you. Now, can you use a trust to get asset protection? A irrevocable trust, yes, you can use an irrevocable trust to get asset protection, but you have to basically give away your property to this irrevocable trust. It's complicated and it's often expensive. So if asset protection is something that you're concerned about, we could use a trust, but this conversation, this presentation was all about a revocable living trust, which does not provide any asset protection. So if you want to talk about asset protection through an irrevocable, let's talk about that after.
And though what you would do, let's say you get some asset protection from a limited liability company. Well, then how do you manage everything we're talking about? you would transfer your membership interest from that LLC to your trust. So now you have limited liability because your property is in an LLC and your membership interest is now owned by your trust. So now you have the protection from not having to do probate. So that's how they work together.
Yeah, for most people who aren't of uber wealth, an LLC or a corporation is a much, much better way of gaining asset protection than an irrevocable trust. Just a general point.
And then whatever that is, again, we put that asset into that's the funding that Mark talked about. So now you have the asset protection and the probate protection.
Can you talk about that a little more? Because between me and my husband, we each are sole proprietor LLCs on our own. So it'd be helpful to understand that point a little more.
Very simple.
Hold on. When you say sole
Yeah.
proprietor LLCs, you mean single member LLCs.
Yeah.
You're not sole
Yeah.
proprietor. Okay, go ahead.
Yeah, very simple. We do nothing with your LLC, but you are the member of your LLC. So we take your membership interest and we prepare a document that transfers your membership interest into the trust. So nothing has changed on your LLC, but now it's part of your trust, so it avoids the probate. And it's a very simple process.
And it can be inherited and transferred.
Exactly. So then what happens when you pass away, it's not, the LLC doesn't do anything. It's the membership interest in the trust. So in your trust, if your trust says my membership interest goes to my kids, now your kids inherit the membership interest through the trust. And then the terms of the LLC will say, well, what happens when a transfer happens? So the terms of the LLC will still apply to whatever that membership interest is.
So, like, if you remember, we talked about titling assets. So, just like your house has will eventually have your trust as the owner, your LLC has to have your trust as the owner. So, everything that has an ownership interest has to basically be renamed into the trust.
But very, very, very simple. You would change nothing on your LLC. Well, that's not true. We would maybe do an amendment that just says you as trustee are now
The owner.
the owner instead of you personally.
Okay.
Very simple to do. And nothing would change in your LLC.
And that applies to corporations
Yeah.
and stock certificates, and there's other different types of entities that have ownership.
But again, a really thing, if you had gone to LegalZoom, you might not have known that. And here, both of you, your business, which is probably some of your biggest assets, are not in the trust.
Right.
And that's the kind of stuff that you just don't get when you do it on your own.
Good questions. Anything else? All right. Thank you, guys. And listen, there are some sheets that if you want some more information or you want to be part of our database so that we reach out to you when laws change, just fill that out, hand it in, and we'll be more than happy to reach out to you if you want, or just add you to our database if that's what you want. Okay?
Great. Thank you.